book, it talks about, in Title III, United States jurisdiction. There it is, Article 1, 2, and 3, in Title III, property ceded to the United States. So in this, we learned that in these sections, jurisdiction of United States over land, jurisdiction over the Denver Public Building, how this is the section of law where you want to find out if the federal government has jurisdiction in Colorado. This is where you go. Now watch this. This is really cool. That's it. That's it. In these pages, which there are, let me see, we go from page 3 to page, we go from page, they don't number them, Mike.
So Dave, if you're talking about that, this is coming close to home because this is just a recent issue we faced here. I don't know if we ever got clarification on it, Linda, but the Colorado National Monument in that Title III is not listed on there. It is jurisdictionally joint jurisdiction.
Actually, it is listed in here. I'm going to show you. That's not. Let me see if it's here. Okay, right there. Colorado National Monument. Okay.
Under what's
Okay, this is under 3-3-101. Concurrent jurisdiction of the United States over certain land dedicated to national park purposes. Concurrent legislative jurisdiction under the laws of the state is ceded to the United States. Now let me go slow. Under the laws of this state is ceded to the United States over and within all the lands dedicated to national park purposes in the following tracts. Here's Black Canyon of the Gunnison. Here's Colorado.
What concurrent jurisdiction means?
Well, now that's, remember I was showing you the maximum of law where two people can't own the same piece of property? Concurrent jurisdiction is the curiosity. And it's something that I've been studying, and it appears from my studies so far, and I'll let you know if I come up with something to the contrary, but we have an opportunity to test it.
Yep.
Concurrent legislative jurisdiction, what it says is, as long as the federal government is operating within the scope of its powers granted by the Constitution, it can exercise power inside that Colorado National
Does
Monument.
it have a date on there? When that happened?
This,
all I'm saying is that the Antilles Act, or
Antiquities Act?
Was it Antiquities of Center, granted the president the authority to take federal-owned land and designate it as a monument, but they had to own it first.
Yes, that's.
So I'm saying is there's a difference there, and there's not a longitude, latitude restriction of ceding this property ever in this title that I can find.
When Colorado ceded the land to the federal government, did they issue a deed for it?
In order, okay, the procedure is written right into the Constitution and in the statute. The General Assembly has to vote to cede the land. Then the governor has to authorize the cession and then sends it to the federal government, and I'm not sure, but I think it's the Attorney General, might be the Secretary of State, has to accept the secession or the cession into its jurisdiction. And so there's a very specific procedure that has to be followed.
Here's my point.
Yes.
Did they cede the land, or did they cede the jurisdiction to the federal government?
They ceded jurisdiction.
But not the land.
That's what
There
I
is
mean.
no deed
Based
in the
on what
name
I
of the
looked
federal
at, I
government.
could not find any ceding of actual property boundaries under that title for the Colorado National Monument. I could not find it. All I could find was an Antiquities Act where the president said, we have the Colorado National Monument, and then only in that act that he did are there ordinance listed, but not in the Colorado Constitution are there ordinance that was given up.
Somewhere there is, and I've done the research on Curacante. I contacted the National Park Service and I asked them to send me a copy of the boundaries of Curacante National Recreation Area, which is in this list. I was researching that. I did find the boundaries that were created in about the 1960s, when when the reservoir, when the dam was first built. Maybe it was the 50s. But the boundaries were what the state of Colorado was using to declare Curacante to grant concurrent jurisdiction. So it appears that when they built the recreation area, ownership of the land was transferred to the federal government, operating through the Department of the Interior. So
Yeah, I'm just curious, because I don't know, I've not ever bought a park thing, but can you, if you buy a state park pass, do you get in Colorado National Monument, no charge?
I don't know.
A state?
No,
Yes. Yes.
a state
Yes,
park?
you can. Yeah.
You can't.
They
I
told
don't know.
you you can.
This is a excellent, and thanks Kevin for asking this question. This is where our research needs to take us, and it's where it's taking me. I want to get my mind around concurrent jurisdiction, because it appears that we have two sovereign powers competing for the same area of land, and that would be a violation of a fundamental maxim.
Actually,
Right.
3, wouldn't you say, David? It's we the people, the state of Colorado, and the federal government.
Well, again, the people are the sovereign,
Yes.
and the people delegated power. So if they're operating within the scope of a delegated power, the people have authorized them to do that. It's when they cease to operate within the scope of that delegated power that the power reverts back to the people. Now, we gave some to the state and we gave some to the federal government. And so now it sounds like the state and the federal government are operating concurrently within these areas. And I'm operating from the premise, and we're about to test this. We have an opportunity to take a case into the courts, and over the next several months, we'll be able to give you a report on what's happening. We're going to approach the case as though the federal government has no police power inside these national monuments or national parks, because the federal Constitution never delegated police power to the federal government. The only power that they have is to operate, to make needful rules and regulations over areas that were intended for dockyards. I have that. Hang on, let me go find that. I'll show you that right here.
Yeah, but Dave, backing up, one of our local senators just gave, they keep continuing to give police powers to federal agencies within the state.
If that comes through the, yeah, boy. Again, what's a usurpation? That needs to be challenged as an unconstitutional grant. The statute itself. There's a principle in law, and it's called the presumption of regularity. There's a presumption that all legislative acts are constitutional. We begin with that. So anybody challenging an act as unconstitutional carries the burden of proof to prove that it's unconstitutional. So the sheriffs carry the burden of proof when they sued Hickenlooper in the state of Colorado for passing those magazine bans. So they're the plaintiff, and they carry the burden of proof, and they have to prove those statutes as unconstitutional. It would be the same in an area where the legislature passed a law that we know is unconstitutional. If nobody challenges it, it's presumed to be constitutional. It's presumed to be regular.
Until this challenge, or?
Until a court comes down and throws it down as unconstitutional, it's presumed to be constitutional. So that's what we're working against. So as long as we do nothing, then everything the government is doing is presumed to be valid. That's the hurdle that we face. Getting back to this, this here is the jurisdictional statute that the federal government has relative to the Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district, and this is not exceeding 10 square miles, District of Columbia, as may be by section, sorry, of particular space and the acceptance of Congress become the seat of the government, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Okay, let me ask you. Up there on the monument, are they erecting forts?
No.
Magazines?
No.
Arsenals?
No.
Dockyards?
Nope.
Needful building?
Needful buildings related to the foregoing? No. So any rules and regulations, if they're outside the scope of that authority, that's outside the scope of the jurisdiction intended by Congress.
And it says purchased as well.
Yeah, so did they purchase the monument before? So who owns the monument? And you're right, if the state still owns the monument, but they ceded concurrent jurisdiction, who ultimately has the police power up there on that monument?
The owner of the land.
I say the state of Colorado. And I can't get into too much detail, but suffice it to say that something happened inside of a national park back when there was a shutdown, and the national park called the sheriff to come up and investigate the incident. So for some reason, the national park agents felt that they didn't have the jurisdiction to take care of it themselves.
It's a mutual aid agreement, what I was told.
Okay, well, you know what? All of that information can be discovered. All that information can be obtained through the Freedom of Information Act. That information cannot be hidden, so it's obtainable. Barb?
So the monument is not a park, and that's how come they can't use a state national park tag to get into the monument.
Well, it is a park.
No,
So
well, but they've
You're
made,
able to get in or not able to get in?
no.
No.
And because they've made this separation, and I can remember when they were trying to make the monument a national park, and they still are. But there's still that separation there, that it's a monument and not a park. And didn't Scott Tipton go along with trying to make that a national park?
Yes, he did.
Okay, but not yet. It's still a national monument, but still, it's that concurrent
Well,
jurisdiction.
yeah, and I'll get back to the current.
I think, David,
Yes.
that what you had on here before, the forts, magazines, arsenals, post office, this right here is specifically laid out by the Supreme Court as reserved lands, and the other lands, the parks and all that we're talking about, are called public domain. So when we do our research, we need to research reserved lands and then a separate public domain.
This is another clause in the Constitution that the Congress exercises its power to authorize the Forest Service and the BLM to do what they do. Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Well, now I'm going to show you here, again, this issue with these books here. Jurisdiction over areas within the states. This is an inventory report that talks about everything we're talking about. Proprietary interest only is Code 4. It applies for those instances wherein the federal government has acquired some right or title to an area, but has not obtained any measure of the state's authority over the area. The United States may hold or acquire property within the borders of the state without acquiring jurisdiction. So even though the federal government may own property, it doesn't mean that they have the same power inside that enclave as a government. They have a proprietary interest, just like anybody else that would own that interest. And they own that property subject to the state's power. I asked Rob Shalekas, the BLM agent that was investigating the removal of that barricade, I said, well, okay, let me ask you a question. Does the BLM have jurisdiction inside, we were over at the Red Barn in Montrose, inside this bar right here, where we're having this conversation? He says, oh, no, not at all. Okay, so you do recognize there's a limitation to your jurisdiction? He says, yes. I said, okay, now let's go on to BLM land. If a murder happens on BLM land, the land managed by the BLM, who has jurisdiction? He says, well, the sheriff. We're talking murder here. So who has jurisdiction on BLM over murder? Well, it would be the sheriff. Okay, so you got that. So I got an acknowledgement from the guy investigating us, tearing out a barricade, got him to acknowledge that he, the federal government, didn't have jurisdiction over a murder on BLM land. I said, so now let's move to the road. This is a county road. What makes you think you have jurisdiction over an alleged crime that happened on a county road if you don't have jurisdiction here in the bar or on BLM land? He said, well, we think we do.
That was it.
We think we do. And I said, well, where did you get that? He says, well, the people I work for told me that I do. I says, well, you, as an investigator, isn't your first investigation to determine whether you have jurisdiction or not? Before you even come in here and talk to me, have you done that research? Well, no. So he acknowledged that there was limitations to his power, but he wouldn't get off the road. He was arguing that they had jurisdiction over the road and over the crime, alleged crime that happened on the road because it was destruction of federal property. Jurisdiction. Okay? State and federal. It is real and it is a limitation and they know it. Now, we've talked to the sheriff, we've talked to the commissioners. They didn't know. They didn't know. We haven't been taught this in school. They are not teaching this in the police academy. So this is a very important place to begin our education, because if we, as the people of Colorado, want some protection from our sheriff, we need to get him to understand that he represents us. And he's not merely an agent of the federal government. That's what Richard Mack's case was about. Sheriff Richard Mack challenged the federal government's jurisdiction in his county when they ordered him to implement the Brady Bill mandates. Right. And he said, no, that's not happening. And so he brought a lawsuit against the federal government. It worked its way all the way to the Supreme Court, and the Supreme Court agreed with Richard Mack. You are representative of the people of the state of Arizona at the time, and you don't have to comply with a federal mandate. Now, it was an unfunded mandate, but it was a mandate nonetheless. So Richard Mack set into motion the revival, if you will, that there is a serious distinction between the state and the federal government when it comes to law enforcement. Again, this report makes the same distinction with respect to federally managed lands where the federal government is a proprietor. The BLM is a proprietor on those lands. It does not have the exclusive legislative jurisdiction to exercise police power out there. And this is the case where they actually talk about it.
Dave?
Yes, sir.
On these lands, and there's movement in Utah right now to take, quote unquote, take back of federal lands. It seems like the federal government understands that it is in a caretaker position only on it.
Yes.
So that they know that they do not own the land. They're just caretaking it.
Yes.
Is that acknowledged in this?
Yes. Yes, it's clearly established law. It's so clearly established that if you go talk to a BLM, you know, the guy with the bulletproof vest on, you know, that almost says SWAT on his back, and he's driving the Homeland Security vehicle, if you just go up and ask him point blank, what's your jurisdiction? They know. Now, I've seen somebody, I think you posted it on your website, the DHS vehicle was up here in Grand Junction.
Yeah, that was, it said Department of Homeland was it
Police?
Homeland Security?
Yeah.
It was patrolling. Supposedly they have the power to patrol the federal office building. I guess it's the Aspinall building down on Rood. They just have the power to patrol the federal building, but